So I suggest that we start, and the next speaker is Florian Idelberger. He has to be congratulated because the reason why he's not with us, I think it's one of the best reasons. It's not a tropical storm in Indonesia, but he defended his PhD yesterday publicly. So if you are with us, I can't see you yet, congratulations. Maybe it would be nice that we now give him a big applause because I can see him now. The floor is yours for the next 15 minutes, and then the replier will come in and comment.
Yeah, thank you, Mireille, for this warm welcome. And thank you, everybody, for the big applause. Yeah, it was a nice and sunny day. Well, cloudy, but also sunny day yesterday, so that was nice. And I'm happy to be here still remotely today to tell you about a part of my thesis, which relates to the uncanny valley of computable contracts, or more specific to what I call the uncanny valley of controlled natural languages. Yeah, so let's start with that. So in my research, well, basically I looked a lot at different contract automation and similar techniques, and then yeah, there's basically a lot out there. It's progressing in many ways, and one way is also to automate kind of the contract, the notion of contract as a document itself, and not only like put it in some different system, like for example, a centralized system that one company runs and then everybody has to use that to basically automate their legal matters. And what I specifically looked at, which is of course quite niche, but I found it very interesting and might also be part of some solutions, if CNLs, which is controlled natural languages, can be part of the solution, either for input, for output, or for both. And controlled natural languages are basically based on a natural language like English, and then certain grammatical constructs, certain verbs and other things are restricted so that they are becoming less vague and more deterministic. And so the idea is that then for both for humans and for machines, they become more clear and more easily readable. So in this research, I basically look towards the notion of computable contracts, which was first established by Sturden in 2011-12, I think. And it also shows again why this topic is still of quite some importance, because from 2011 to basically now, the use of this term went basically from around 8 publications mentioning this term to like over 300 today, and still growing. So yeah, I think this shows how this research is at least on an upward trajectory. And for certain, it was always the focus for computable contracts were always on a certain degree of automation based on a discrete contract that has some discrete factors can be described and tested, and is based on some sort of data so that it can actually be automated. And yeah, it works best for certain domains. And also he called this kind of the ex ante automated assessment compared to, let's say, ex post adjudication by a court. And yeah, then I added to the definition that I also think it would be good if they would be accessible by humans and machines alike, which I think was not in his definition. And if we wanted to look at a broader definition of computable contracts, which some authors also used, then you could maybe call them implicit computable contracts, which would be, for example, platforms, because they're, let's say, there's code-driven law and say or code-driven rules but there's no explicit construct of a document or that's as self-contained as a legal contract, basically. What I also found interesting in this, in the course of this research, is that while we have like more modern invented languages or like controlled natural languages, they're over history also similar, also kind of in law, but not only in law. There were many interested inventors that tried to invent more logical or otherwise better languages for various objectives, like some thought it would help them find God, or some enlightenment, or that just by using this language, people would actually think better. And that's still a hypothesis that exists, but I think nobody could prove it so far, and maybe never will. And some of those that had some bit of community, for example, like Esperanto, kind of survived, but still, of course, like only at the edges, so to speak. And I think of all the controlled natural languages that I looked at, this is also still kind of the problem, that they need a certain kind of growth or community to survive, and otherwise they might stay very niche. Then for comparing the usefulness for computable contracts of these CNLs, I kind of used 3 different things, basically. In a way, I did like what I call like an observational methodology when I use such a controlled natural language myself. And then in a way also observational for the reader by showing examples. And what I did in my thesis, which I so far didn't have the space to expand in this paper, for example, that I compared these CNLs also based on criteria I defined, which is the Pence scale developed by Kuhn in 2014, I think, where he basically relates them based on precision, expressiveness, naturalness, and simplicity. And then I added to that the factors of contract representation, automation, business impact, and aesthetics. Though I didn't rate them as objectively as he did. He graded them from like 1 to 5, and for me it's more like a subjective assessment. And I hope to expand on this in a possible publication after this conference. So if we first look at attempt to control English, which I generally like very much, because it's like maybe one of the most advanced controlled natural languages, because it has very natural sentences, for example. But although if the text gets longer, it becomes quite unnatural. And if you would try to write it yourself, you would also notice that some conditions, for example, are only writable in a very if something, then something manner, as far as I'm aware at least. And if you try to write it differently, then it's either not possible, or it becomes even much harder to write. And what is might be a problem with it, but not so far as it tries to be like a natural everyday natural language. But if you talk about mapping like a controlled natural language to a code environment or an execution environment, then it doesn't have any inherent grounding. So of course it doesn't really know what an identity or what a person is or things like that. And in some more domain-specific languages, this would be more clearly defined and then would more be easily implementable for a contract. Also a very nice one is Logical English by Robert Kowalski, which is built on Prolog and also often described as syntactic sugar on top of Prolog. It can also have very natural sentences and structures. So, for example, what I found that is here in the top right, for example, you see basic structure, and what I think it had in an early iteration, or what others, for example, have, is that the basic document template you have also looks kind of like a contract. And I think if there's any chance of such a language being a usable interface for input or output, then, or especially for input, then it also needs to look kind of familiar. And as you can see here, for example, we have first templates that I find, and these are basically sentences that are then recognized as rules. The knowledge base, which then defines rules, then scenarios and queries. And scenarios are basically certain circumstances which can then be queried. So it's very like a lot of things have to be defined first because before you can get any use out of it. And but if you do that, then it can be quite useful and can answer, for example, how it got to a certain result. And for example, a more contract-looking one, let's say, is Lexon, which was developed to focus on smart contracts at first, and then the latest iteration that I know of also experimented with modeling laws, for example, or compiling to non-blockchain based languages. But for example, as far as I understand, there's also not, it has more this structure, for example, which lends itself to contracts. But on the other hand, there's no really formal verification of, okay, if you have a certain thing, then it does this in the output language, as far as I understand, and this can be quite problematic. And it's also, to some degree, the author still might need to know basic programming principles, because, for example, it has these things called clauses, which is very nice because it's kind of a contract term. It looks similar to contracts. However, these map to functions in Solidity, for example. And then if you're not familiar with what functions do in Solidity, then this is, of course, breaks down at some point, and then people have to know more about imperative programming than they might know. And I, in the paper, also wanted to mention for completeness that there's languages like CNL4 developed in Singapore, which is like more for law and regulation, and has an optional CNL. And there's also, as I think, especially here at CRCL, people know that there's Katala, for example, also for law and regulation. Though it's not, I mean, it has can incorporate natural language text, but it's not really CNL, but I also wanted to mention it for completeness sake. And so basically all these comparisons and observations led me to what I call the uncanny valley of controlled natural languages. And this is also, I mean, as I freely admit, it's not really a new concept. Well, the term is a new concept, but many of the prior authors know this in principle, and sometimes also say this, that these languages are like they might have, at least for some sentences, are easy to read, but then the more complex it gets, the more difficult it gets, and that they are hard to write and hard to master. But I still think this effect is, for example, not very well known, or at least if people read these authors' papers, for example, then apparently nobody cares about this, because I see that even newer developments like Lexon and Logical English, they still seem to make similar mistakes, in my opinion, that they don't really focus on the user, like who is actually going to use this. And even if I like, for example, a controlled natural language as an output or input interface, but then, yeah, nobody really knows who's going to use it, or there's no really clear case for who would use this when, then, yeah, like kind of what's the point? Why are we or other researchers then making the same mistake basically again? And yeah, that's why I wanted to establish this term, to make this basically more prominent, and kind of maybe improve future research with that. And then you can see here basically that based on certain formalisms that are not CNLs, they become kind of more natural. And then as they become kind of quite natural, at least for some texts, the acceptance and the ease of use kind of craters. And then the domain-specific ones are kind of in between. And then if there would be like more like natural language, even then it might reach like a plateau or a higher level again. And it's named after this effect of the Uncanny Valley that was first hypothesized by a Japanese researcher called Mori for the effect of humanoid androids on humans. Then I also looked at CNLs as interface, and the most important thing was the text as an interface, and especially for lawyers, in some ways, maybe the most important one. That's why, for example, I looked at CNLs and text and not like graphical interfaces, for example. But of course, this also has limitations. It could also be not compatible with certain contracting rituals. And I also wanted to look at CNLs as legalism. What I mean by that, I know that with some reviewers, for example, this caused a little bit of confusion. I mean by that, for example, for me, smart contracts, for example, are a term of computable contract, a kind of computable contract. And what they kind of perpetuate is that, well, we only need to put everything in the right kind of code or right kind of contract, and then, well, things will be better. And I don't agree with that. And while I like controlled natural languages, and I think they might do good if they get better, I don't want to them to perpetuate legalism as a kind of code-driven law that misses delays and affordances as described by Laurence Diver, for example. And so they're easy to read, but hard to learn, and could be much better. And what I think they would really need is probably an open interoperable environment that provides certain grounding functions, for example. And but who knows if we'll get to something like this. Thank you.
Our general co-chair, Katie Atkinson.
Thank you very much. Can you hear me okay, Florian?
Yes.
Yes. So I thought the paper tackled a prescient problem because it picks up on struggles faced when targeting legal applications that try to combine human and machine accessibility. And I thought you articulated the case very well in terms of the specific focus on controlled natural languages. That conclusion that you mentioned there is brought up front early on in the paper, in that CNLs are characterized as hard to learn and write without extensive help. And that's often something that inventors fail to provide, or they only develop as an afterthought. And that made me think more broadly about this problem that you find in other areas of software engineering. So perhaps actually this shouldn't be a surprise, but with the relatively recent use of controlled natural languages in legal applications, then it raises its head in this setting. I thought you characterised the issue well, and I'll just quote something that you wrote in the paper. So invented languages often focused on internal logic or perceived improvements over existing natural languages, seldom on accessibility and seldomly on the legal domain. So I do think that's the complaint that we often hear when no matter what the domain, somebody says, well, you didn't think about the accessibility until afterwards, you just did what you thought was in your head without necessarily thinking about the end users. And I thought you demonstrated this point well with examples and empathetic commentary about the hypothesis and made it explainable to the audience. And another characterization I like that you picked up on that fits well with the philosophy of the conference is about law in practice the need to do law in practice rather than law in abstract, because the people are the end users here, so we need to focus on what they want, and that's a gap there. So it was, I'm a computer scientist commenting on this, but I actually found it quite a computer sciencey paper, even though we're coming from different disciplines. But you were unapologetically approaching this from a socio-technical approach, and I liked that and the demonstration on those different examples that you used. But I like that you recognised as well that further work would be needed to cement the hypothesis through empirical studies. So you briefly showed in your slides this survey of the current landscape of controlled natural languages, highlighting particular instances. I'll just pick out some of the points to demonstrate those accessibility issues. So only permitting, say, the use of the present tense and the active voice in the ACE controlled natural language. Plural noun phrases and modal verbs aren't supported. Again, that's something that would be needed for use in practice. So I thought these were all valid observations that can be generalised about that key trade-off involved in formalisations, about the need to be precise and unambiguous, but still sufficiently expressive. And that's often a struggle that we find in these formalisations. You claim that the issue, coupled with the lack of domain grounding, is giving rise to hindrance in both adoption and accessibility. Though on that point, you did conjecture in the paper that these shortcomings could be addressed through modifications. And that's the first question that I've got is, what do you envisage these modifications would be to address those issues about hindrance with adoption and accessibility? I also liked that you looked to some of the past relevant literature, in particular the landmark work on the British Nationality Act, when that was modelled as a logic programme in early work in AI and law. And that paper was one of the first to note issues in making the law computable. And again, I'd be interested to hear your views on the extent to which you think the hurdles that were noted in that early paper persist in today's literature on computable law applications, and why they remain so, because that work was from the 1980s, yet we still seem to be struggling with these problems nowadays. That work was done in Prologue. You mentioned logical English, and with that phrase that it's just syntactic sugar on top of Prologue, so it's still failing to meet these accessibility requirements. You reviewed more recent CNNs on tasks involving blockchain-based smart contracts, and particularly in relation to the Solidity language. And whilst finding that to be much more readable, they're still not problem-free, because they require, in what you said was at least a non-negligible familiarity with Solidity as a smart contract programming language. And that brings me to my next question. Okay, so people have to be trained in using these. Is that actually a problem? If somebody's going to be doing this regularly in their day-to-day work, we would expect somebody to be trained on how to use the tools that are needed to do their job if they're going to be doing this on a regular basis. So perhaps they might not be immediately obvious and intuitive to pick up, but perhaps training would actually solve the problem, and the gap isn't as problematic as perceived. So the conclusion of your review brings us to that analogy that you made from robotics about the uncanny valley, and applying it to law gives that learning and writing human readable and writable computable contracts using controlled natural languages will be rejected until the computable contracts become almost indistinguishable from natural language ones. And in that discussion, an interesting point I thought was that you said, despite the domain-specific languages being in that valley, they're also the best bet for getting out of that valley. So instead of helping adoption and understanding of the computable contract, the controlled natural language makes it harder to understand and creates confusion. But from that, I took the message that you were saying, that doesn't mean because they're in the valley, we should throw them away, we should persist with them. And that made me think about how this point can be related to the general issue about the hype in new technologies, both in legal tech and also more generally in AI. So when something is shown to work in a particular example, in a particular context, then we often get the evangelists starting to make statements about the potential general application of that technique. And I think a lot of people are just sick of the hype and just want realism in this. The hype can lead to overinflated expectations and ultimately disappoint before more measured outcomes can be achieved. And the graph that you showed there reminded me of these often quoted hype cycles that you see about new technologies. The main one is the Gartner hype cycle that's often referred to, where we see these technologies that everybody gets excited about and then they go into the trough of disillusionment before coming out the other side with a more measured response. So I think that speaks to a key balancing act that academic communities may not along the way in getting to those envisaged end benefits. And that might be a journey as part of future development. So I think generally your point illustrates to something that often arises with new technologies, that usability is the key to getting these actually out there and used in the wild. And this relates to some of the wider discussions that we've been having in the conference and on some of the papers yesterday. And also to the point that you mentioned about computational legalism, so constraining law to the limits of code, which we've heard from others can be a dangerous thing to do. So I thought you drew some very nice clear conclusions from the study that controlled natural languages can make computable contracts more readable, but they're not very helpful for making them more accessible and user-friendly. They sit in this unfortunate middle ground between a programming language and a real natural language, and you've used that term uncanny valley there from robotics to characterize that. And you said that the reason for doing this was to name this concept in order to give an easier way to reference the phenomenon and connect formerly disconnected strands of the literature. But then my final set of questions are focused on where do we go on the path forward from this. So I'd be interested to hear your views on whether you think people should perhaps throw away what we've got already and start working on controlled natural languages from a different user-oriented perspective. So start thinking about the users. First of all, you said that they're the best bet of getting out of that, and I'd be out of that valley, and I'd be really interested to hear your insights on how you think practically they could be involved in order to help climb that hill out of that valley. And finally, the focus of the paper is on the controlled natural languages for contracts, but do you think this uncanny valley analogy can apply to other aspects of legal tech too? Hopefully my questions were all pinpointed within that.
Florian, the floor is yours. I think you're muted.
Sorry about that. So I hope I got all the questions. Otherwise, please let me know. So I think the first one was kind of what I think the hindrance to adoption is basically, or what could be changes. Of course, I don't claim to have like a complete or good answer to that. I've worked or was in discussions with some developers of logical English, for example, and so I'm not really sure. It could be either like having a more strict structure for like what you actually, which contracts you need, which constructs you need, and which you then do, and then kind of iteratively test with a number of users. Where instead what happened sometimes maybe was that people just test it one by one with, let's say, one person or one company, and then they made some changes, but then this wasn't suitable for other users or other companies. So this might also point to that you need just a custom solution or something like that, or you might need a combination of a controlled natural languages and some other software system or AI system, where, yeah, I'm not really sure. Am I there again?
Yeah. Yeah, so I understand that the essence of the paper was about identifying and naming the problem. I just wondered if you had thoughts, having seen those issues.
What? Somehow I have like audio from the waiting room or something.
I'm not entirely sure what's going on now. I thought you were still, Florian, in the midst of responding to Katie's question. Or are you finished with that? I thought you had answered the first question or responded to it, but there were some more.
Do you want me to repeat the second?
Can you hear us?
He's gone.
Oh, okay. Interesting, but he's coming back, I'm sure. There he is. So can you hear us, Florian?
Yes.
Oh, okay. So I think you were, I think you addressed the first question, but there are still, so if you want to respond to the further questions, please go ahead.
Yeah, so the next one was about the hurdles in the Nationality Act in the UK. And I think the main issue that was criticized in that paper was that they didn't really have a formal structure, like when or how which rules were translated in which way. So it was all very ad hoc. And if you would do this either for contracts or for legislation, then I think you would need like quite a strict like set of rules, like how you actually do this, or try to automate it or something like that. Because if you just let humans do basically try to do it like ad hoc, this will probably not work very well and not have a consistent outcome. Then you also asked if training is an issue. And I think, no, of course, it's not generally an issue, but what I think is often the marketing pitch or the appeal, that because they read like natural languages, or kind of, you wouldn't actually need the training, and that's why they're better than, let's say, needing training for like a business modeling system or like another graphical interface system. But of course, that's not really the case. Yeah. Then if you also asked how to go forward from this, and if it was maybe necessary to throw away CNLs. And I think it's probably not necessary to throw them away, but for example, it could be necessary to like very clearly target them to one specific use and then stick with that, or combine them with different other technologies that make them more usable. And yeah, and then you asked also about if the domain-specific languages are the best way of getting out, and I think this is precisely because they to some degree have kind of this grounding and where certain terms or constructs are defined in some way that they're tied to an entity like an identity, or a construct like an identity, for example, or an account. And then this is also easier to intuit for both machines and for humans when they, for example, know, okay, certain terms are tied to something else already. And you also asked about the uncanny valley in other legal technology. And well, I haven't thought about it too much, to be honest, but it's definitely possible. Of course, it wouldn't necessarily have to be a valley. It could also be, even in this case, of course, it could also be that if you would actually have like data, it could be that it's more like a plateau at some point, or has a different form. But definitely also with other technology, it could be that at some point, okay, people are just like, yeah, we don't want to use this. Like I gave the example yesterday, for example, that if we talk about, for example, talk about adoption of more advanced AI, but many like small businesses or legal practices don't even have like proper workflows in place yet that use like just normal templating tools, for example, that have been available for quite some time, then yeah, why would they invest in this more advanced system, for example, if they're not even using like a quite basic but very efficient system that could help them automate? Yeah, thank you. I hope that answers some of your questions.
Completely. So we are, of course, in a difficult situation as to timing, right? So my proposal is the following. There are questions in the chat. So Florian, if you could look in the chat and maybe answer them. And I'm going to ask to take the questions that are here. I've not seen hands yet. Take the questions, but we're not going to answer them. You are not going to answer them. I'm very sorry about that. But maybe considering the fact that you have just publicly answered a lot of questions about your PhD yesterday, it might also be a relief not have to do that in extension again today, so that we can move to the next speaker, who is probably already sitting ready in Australia to be speaking. Questions? Lawrence.
Hi, Florian. I'm interested in the idea of, you don't have to answer this, of course, but I'm interested in the idea of syntactic sugar and whether in some cases the sugar is in fact poison. Because the better the syntactic sugar, the more easily understood the language is by non-technologists. Does that not run the risk of luring those non-technologists into the belief that the substance of the contract, when executed, is the same as a natural language contract would have been? And therefore we end up in this situation where they think it's going to do one thing, i.e. what an actual natural language contract would do, but in fact it does another thing entirely. And because they don't have the technical background to understand that it's a CNL they're looking at, they think it's natural language. They could be led to believe that its performance will be orthodox as opposed to computational. So I just wondered if, in a sense, we want things to stay not in the uncanny valley, but to go backwards, to be more technical, so it's absolutely clear that they're not natural language. This is just a provocation. I'm not suggesting that that's correct, but I just wondered if you had any thoughts on that in terms of the legitimacy of such a contract.
Let's add some more sugar to that. So this goes back to the discussion that we just had about shared vocabulary. I think the uncanny valley sits in that shared vocabulary, and that is what messes people up. I see one more question. I'm just going to take questions and then we stop. But I think this paper actually is exemplary for the sort of papers that we want on a conference, because they bring to the fore all the issues that we are encountering from different perspectives. Giovanni.
Yeah, so there was one point in one of the slides in which we were making, can you hear me or so?
So, hello, hi. Thank you very much for your presentation. The topic, I think, is also very relevant from a technological point of view, because indeed that's an interface of whatever we are doing on the computational side with how people are going to use it. I should look at that, but I'm in any case far from the camera. So, just to return a little bit I can understand all the problem about the poison sugar that Lawrence was making reference to. But on the other hand, let's imagine that we have a clock. No, so I mean, again, it's a matter of design stance. The clock, we don't know anything about how it is built within, but there is a kind of a shared agreement that the signs that are over it, what they mean, and we can utilize it because there is a coupling between this layer interface that we have and what we expected that what will happen within. So the fact we cannot even renounce completely to that, because then that means you will always just dependent on having someone that is looking at all the internal components of the clock. So to try to understand where the interface is, it's actually rather critical. And that's why I wouldn't dismiss completely the attempt to go towards control natural languages, because still they have, if you want, something which is a robustness component. It's just not purely statistical based NLP. So there is some more clear correspondence to what is a program under the hood. But on the other hand, I recognize all the problems that you have experienced by using them, that still they are far, let's say, from being usable in an actual sense, in actual contract. So let's say that I have, again, a more nuanced view of that, in the sense that there is still something to be done there, or at least to be attempted.
Thank you. Any more questions? Okay. I'm going to post in the chat the link to the thesis of Megan Ma. Maybe some of you are familiar with it, because in the thesis she has a wonderful rendering of the whole discussion about controlled natural language, where she also visits this huge literature about whether lawyers should stop speaking a controlled natural language, because in law terms have specific meanings.
Could you also, maybe for all of the work that you're referring to for your team, send an email to the in-person attendees at the end, because I don't think we're all on the chat and it disappears.
Yeah, that's very good. Yeah.
Work from your team that hasn't been presented here, so maybe for the in-person people you could circulate at the end.
Yes, both the team and some of the other relevant stuff here. Yeah, perfect. Yeah, I'll nevertheless post it in the in the chat for people who want to already check. Yeah, perfect. Okay, Florian, thank you very much, and I wish you a continuation of your celebration, because I'm sure it's time to enjoy the new status, right? Okay.